When the bill was first introduced, it didn't have a sunset clause. It just excluded mental illness. And when it went over to the Senate introduced the sunset clause. And the reason for that is they recognized that it couldn't be excluded forever, because that would be a breach of the Canadian Charter of Rights and Freedoms. It would be discrimination on the basis of mental disorder, because the only people you're excluding are people with a mental disorder, and you don't have a justification for it. And so under the Charter, you wouldn't be allowed to do that. So I think that they recognized that that a delay was justified to give time to regulators and clinicians to develop the standards and the practices and the guidance in order to know how to do MAID MDS-UMC well. So a delay would arguably not violate the Charter. A full-on ban would. So they put in the sunset clause to ensure that the ban would be lifted, so that they wouldn't be sort of immediately subject to yet another charter challenge in court, arguing that the legislation was unconstitutional. And they knew they couldn't do it for a couple of reasons. One is just, if you do a charter analysis, I think it's very clear that to have a ban just on mental disorders is a breach of the equality provisions. But we also have a little more than that, which is that we have the Supreme Court of Canada decision in the Carter case, which is the case that gave us MAID in Canada, and it did not exclude people with mental disorders. We then had a Court of Appeal decision, the EF decision out of the Alberta Court of Appeal, that was a case of a person with a mental disorder as their sole underlying condition. And they gave a constitutional exemption to this woman to enable her to have MAID under Carter. So they were saying effectively, Carter doesn't exclude people with mental disorders as sole underlying condition. And then we also have the Truchon decision, which looked at this issue and looked at the question of what did the Supreme Court think about mental disorders. And the Truchon decision out of Quebec also said, no, Carter did not exclude people with mental disorders. So we have the Charter sitting there on its own, and we also have these decisions, which told Parliament, I think, you can't do a permanent ban. You can do a delay, but you can't do a permanent ban. I also think they were very concerned, rightly concerned, that a ban would be stigmatizing on persons with mental disorders, because it seems to suggest that the suffering that's caused by physical disorder is somehow sufficient and to justify allowing assisted dying, but the suffering from a mental disorder isn't as egregious, it isn't as excruciating. Or it also seems to suggest maybe, people with physical disorders, they have decision-making capacity, but we're not so sure about people with mental disorders, that we have to protect them from making bad decisions. That's so stigmatizing, and it runs counter to what we as a society have been trying to do for decades, which is to acknowledge that the suffering that can come from mental illness is as excruciating as from physical disorders. And also that people with mental disorders absolutely have decision-making capacity. Some don't, just as some people with physical disorders don't have decision-making capacity. But you should not be saying a group of people or suggesting a group of people lack decision-making capacity. And so, we've been fighting for that for years, and to have an exclusion that is stigmatizing in that way, that reanimates those misguided beliefs and attitudes, would be really problematic.